Welcome back, everybody, to Law with Darren, episode 3, When Dogs Attack. So today I'll be covering the dog bite laws for the state of Rhode Island. I'll do Mass in a different episode and Connecticut in another episode because there is more than enough to cover Rhode Island right now and cover a complete episode. So sit back, relax, and take a listen with me as I walk you through the evolution of the Rhode Island dog bite laws. So, dogs are everywhere. People love dogs. People own dogs. I like dogs. However, dogs do have a tendency to cause injuries, whether they bite somebody or they run into somebody or they knock somebody over. So obviously the law recognizes that if you own a dog and your dog hurts somebody, you need to pay. Okay? And that really has been the law since the 1800s. It's been written down into various statutes, and the Rhode Island statute, for those of you who are curious, is Rhode Island General Law. Type in 4-13-16. It's called an action for damages to animals. So, the law states in Rhode Island, if any dog kills, wounds, worries, or assists in killing, wounding, or worrying any sheep, lamb, cattle, horse, hog, swine, fowl, or other domestic animal belonging to or in the possession of any person, or assaults, bites, or otherwise injures any person while traveling in the highway. So that's critical. Remember that. Traveling in the highway, or, this is also very important, out of the enclosure of the owner or keeper of that dog. The owner or keeper of the dog shall be liable to the person aggrieved for all damages sustained, to be recovered in a civil action with costs of suit. So there aren't that many laws in Rhode Island where you can. It's called strict. So it was known as a strict liability statute. So the statute says, if any dog kills, wounds, the owner or keeper of that dog shall be liable to the person aggrieved. So not may, right? Not so. There's a difference in the law. So may is permissible, right? You may, or you can if you want. No, in this state, this statute uses the word shall. So it automatically makes the owner or keeper of that dog automatically liable, no questions asked, if that dog attacks or bites somebody either traveling in the highway, which the highway is not the highways we think of, it can literally just be walking down the street, okay? Or out of the enclosure of the owner or keeper of that dog. So we'll cover what the enclosure means. So this is obviously a pretty brutal statute. So if you own a dog and it bites somebody and it's out of the enclosure or quote on the highway, you are responsible. The only thing the plaintiff has to prove is you own the dog and it bit me, or it actually wounded, killed, worried, assisted in killing, all the other language. Okay. So and then the statute goes a little further, and this is where it gets really crazy. It says if afterwards any such damage done by that dog, the owner or keeper of the dog shall pay to the party aggrieved double the damage to be recovered in the manner set forth, and an order shall be made by the court before whom the second recovery is made for killing the dog. So, if your dog bites, not only do you have to pay, if it's out of the enclosure, automatically, but if it does it again, you get double damages automatically. So that means that whatever the jury decides and the judge orders, so let's say the jury decides $100,000. Judge says, "Okay, jury, thank you. You're free to go home." And then the judge will say, "The law requires me to now double these damages." So this can get out of hand pretty quickly. Okay, so that's the statute that makes people who own dogs responsible. Then there's another statute, which, because if you listen to the original statute 4-13-16, it makes owners or keepers of dogs, right? But what about people who don't own a dog or keep a dog but allow a dog to be on their property, right? Like, for instance, you're a guy and you have a girlfriend and she's kind of a long-term girlfriend and she brings her dog over, where she comes by for 3 days a week, right? And the other 4 days when she's home, she doesn't have the dog with you, right? Well, you could say, I don't own the dog, so I'm not responsible. Well, the law covers that too. So in 4-13-17, called Civil Liability of Person Harboring Dog for Damages, this statute says, any person keeping or harboring in his or her house or on his or her lands any dog, or knowingly suffering this to be done by any other person. So critical. Or knowingly suffering this to be done by any other person, knowingly, shall, not may, shall be liable for all damages done by the dog in the same manner as if he or she were the owner. So basically, this statute says if you keep or harbor a dog. Now, those words, keep or harbor, obviously lawyers like to break those words down. If you keep or harbor a dog, or knowingly allow it to be kept or harbored on your land, you are automatically liable in the same manner as if the dog was yours. So, if the owner of the dog is visiting, their boyfriend, and again, the dog, lives there 3 days a week, and then that dog escapes that land and jumps the fence and bites a neighbor, right? Not only is the dog owner, the girlfriend, responsible, but the boyfriend who owns that property is also responsible, okay? So, clearly the law does not like dogs biting people, and if it does, you are responsible. So control your animal, okay? So that's the basic statute, okay? So now I want to go into kind of, the evolution of the statute. So one of the words I think a lot of you picked up on, and I picked up on, and lawyers picked up on, is what is an enclosure. Now, why is this important, okay? And the reason this is important is because when you read the statute, it, like I said, it automatically makes someone responsible or liable to the injured person if the bite happens on the highway or outside the enclosure. Now, again, on the highway, if the dog, leaves the property line and goes into the middle of the street and bites somebody, no question, right? Clearly, that's done, case over, not much here to talk about except how much we owe, right? But, obviously, the dog needs a home too, right? If the dog's in the house and you come in the house, and, you don't know a dog's there, dogs can be defensive, right? People like dogs because they protect the home. They bark when they hear intruders coming up the driveway. So, and again, everyone loves dogs. So the law has a carve-out, the statute has a carve-out, and says, well, if it's in the enclosure, if it's outside the enclosure, you're automatically responsible. So, as a plaintiff's attorney, obviously the easy slam dunk layup case is to prove that the bite happened outside the enclosure, right? Because then all you have to prove is dog bit my client has injuries. Boom, done. You don't have to prove anything else. You don't have to prove knowledge, that the owner knew the dog was dangerous, nothing of that sort. There is also a carve-out too, by the way, I should say, there's an exception. You can't antagonize a dog. So you can't throw rocks at it, obviously, or stand just outside the fence and then, with your tongue out, going, yeah, hoping to get the dog pissed off and it bites you, and then you try to cry foul and say, oh, the dog bit me. No, you antagonize the dog. So if the defendant can prove that, you lose, okay? So one of the seminal cases on the issue is the case of Wilbur versus Gross. And this is a 1936 case out of Rhode Island where it actually, oddly enough, involved a blind dog. So apparently in the Wilbur versus Gross case, for those of you who are interested, the citation is 55, Rhode Island 473. The plaintiff in that case was invited to the defendant's property. The defendant owned an apple farm, or basically owned a farm, and the plaintiff is walking, and he was invited over to come get some apples. So he comes in. The defendant said, okay, take this path to get to the apples. Plaintiff arrives, doesn't actually take that path, takes a slightly different path on the property between a garage and a barn. And unbeknownst to the plaintiff, there is a dog that is chained up by the barn and bites the plaintiff. Get bit by a blind dog. So I'm not sure how that even happens. The dog doesn't even know where to bite. So you must have been really close to get bit by a blind dog. Either way, in that case, the court really looked at it. So in that case, the plaintiff said, okay, this happened outside the enclosure because, Even though my client, Your Honor, came onto the land, and the land, it's the farm is surrounded by like a stone wall, right? Clearly, the dog was outside of a barn. The dog wasn't inside. So if the dog's not inside a house or a barn, and it's just kind of, even though it's chained up to a barn, the dog doesn't live outside the barn, doesn't live outside, so therefore can't be in the enclosure, and therefore we don't have to prove that the dog, or that the owner, I should say, of the dog knew that the dog had a vicious propensity or had previously bitten, okay? Known as the one bite rule, okay? So, court looked at it, thought about it, and said, well, the point of the statute is that it's not so much to keep dogs in as much as it's to basically place a plaintiff or a potential victim on notice that they're entering a land that's occupied where a dog could be, okay? So basically, in that case, even though, again, the plaintiff came onto the farm and was outside and was on the farmer's property, the court found that, the plaintiff was on notice of potentially running into a dog, okay? So in that case, the Wilbur case, the court did find that the plaintiff could not recover, and that because it happened within the enclosure. So that was that was a big case, and that's cited a lot by a lot of other decisions. So and again, it makes people strictly liable if the bite happens outside the enclosure. But what about kids, right? So kids oftentimes don't know better, and they wander places, right? And they find themselves in situations, and what if a kid's bit by a dog, right? Can a child be held to the same standard as an adult, right? Because in Rhode Island, you're supposed to, children get a little bit of not special pass, but there's often special duties that are assigned to children, and society obviously has an interest in protecting children. So, fast forward about 50 years later to the case of Bernhardt versus 9, citation 120, Rhode Island 692, 1978. In this case, a 3-year-old boy came onto a neighbor's property and went to an area where the neighbor's dog basically has like a little hideaway. From the facts of the case, it appears that the hideaway was like a little like under porch type area, right? So this 3-year-old kid goes to his neighbor's house. I don't know why he wasn't supervised. I don't know how he just walked into his neighbor's yard. I don't know who's watching this kid, but either way, he goes onto the neighbor's property. The neighbor's property is surrounded by shrubs. It's very clear cut, okay? Goes into this area where the dog is just hanging out and gets bit, okay? The issue in this case, this 1978 case, was that the plaintiff argued and wanted the judge to instruct the jury that the meaning of the word enclosure requires some sort of visible or tangible obstruction, like a fence, a hedge, or a ditch, okay, or some equivalent object which protects the premises against encroachment. The judge did not rule that way, okay, and this was the issue on appeal. So, what did the court do in the Bernhardt v. 9 case? Well, court looked back in its decision from Wilbur about 40 years earlier and stated and clarified again that the purpose of the enclosure is to give, the word enclosure is to give the entrant, quote, reasonable notice that he's entering upon occupied premises where there may be a dog. Okay, that's a direct quote. And that requisite notice is afforded if the premises are set apart from adjoining property by boundaries sufficiently apparent to indicate the approximate limits of occupation. Okay? So, in that case, the court went on to reason that there was ample evidence which could indicate that a visitor making his way onto this defendant's property should have noticed that they were about to enter premises which might have a dog, right? You go to someone's house, you walk up their driveway, people own dogs, right? Dogs are everywhere, like I said. So in that situation, the court did find that the bite happened within the enclosure. Obviously, the plaintiff didn't have any evidence that the dog had done this before, so therefore, they lost the case. All right, and in that case, the Supreme Court upheld the instruction given by the judge to the jury defining enclosure by that means. Because if the judge had, made a mistake there, that's called a mistake of law, and then therefore the plaintiff could appeal and argue for a new trial. Okay, so that was the case of Bernhardt versus 1978. But we're not done. So later on, about 8 years later, there was the case of Lamoureux v. Davis. So how about this? So what happens, so now we've covered cases where if you go on someone's property, you're on someone's property and a dog bites, clear cut, people own dogs, it's suburbia, come on. The dog doesn't have to be literally tied up within like a little 4-foot by 8-foot fence, okay, on the property to be considered the enclosure. The enclosure basically is the property line. That's what they more or less found in the Bernhardt v. 9 case, the case with the 3-year-old boy. But what about a situation where someone goes onto land, right? They don't know where they are, and unbeknownst to them, they are in fact on private land, and they're bit by a dog. And it's big land, acres, 10, 20 acres. What happens, right? Well, that's what the court had to address in the case of Lamoureux versus Davis, citation 503A2D 449, 1986. So in this case, the plaintiff, a guy named Robert Lamoureux, and his wife were driving somewhere in Smithfield. They weren't familiar with the area, and they were looking for a swimming hole. I don't even know if those exist anymore. Probably called a pond. Swimming hole, at which Robert's cousin had said they could meet her. As they drove through Smithfield, they came to be on a place called Tarkland Road, which is a public highway. They reached an area where they could see 2 ponds of water about 1,000 feet away and people swimming. A dirt road led to the ponds from Tarkland Road. So Tarkland Road is the public road. There were no gates or barriers across the dirt road. Posts on either side of the road were visible, but there were no signs on the posts and no warning of any kind at or near the entrance of the dirt road to indicate that a traveler would be, in fact, passing from public land or public highway onto private property. So, as this plaintiff, Lamoureux, drove on the dirt road, he did, in fact, find himself on private land. Okay, no big deal. The defendants in this case owned a 30-acre tract of land, which basically ran adjacent to this road, okay? And in fact provided access to these swimming ponds areas, okay? So what happened was, in this case, this Lamoureux guy drives on, is on private land owned by the defendants and has his window down, and literally, apparently out of nowhere, the defendant's Great Dane, which is a tall dog, by the way, I think the tallest dogs, comes in and bites him in the arm. Okay? So, clear cut, obviously, in that case, no one, again, the rule is, from the Bernhardt case with the 3-year-old that, and the Wilbur case, is that, well, the point of the word enclosure is to, place a person on reasonable notice that you're about to enter land where a dog could be kept. But in this case, Lamoureux, there were no such signs, right? There really wasn't much evidence to prove that, right? It was 30 acres of land, right? The guy was in the wrong place at the wrong time with a Great Dane that bites him, okay? So, what happens? Well, actually, I should go back a little bit. So, in this case, the Lamoureux case, the question was, so the plaintiff recovered, and the defendant tried to argue that the dog bite happened within the enclosure because there was evidence that would notify a third person or a private person that they're entering upon land where a dog may be frolicking around. So the jury didn't agree, and what happens is the defendant asked the judge to declare as a matter of law, hey, Your Honor, the plaintiff has not proven or met their burden to show that this happened outside the enclosure, and therefore the defendant argued that it happened within the enclosure, and therefore the plaintiff would have to also show that the defendant had knowledge, right, that this dog would bite. Judge didn't agree, and ultimately the defendant lost. The jury found for the plaintiff and ultimately ruled, well, and then the defendant appealed, saying that the judge made a mistake. Well, in Lamoureux, in this case, the Supreme Court looked at it and said, no, there's enough evidence here to allow reasonable minds to differ as to whether or not, this happened within the enclosure or outside the enclosure. And that reasonable minds could find that it happened outside the enclosure. Okay? So in that case, the court kind of looked at it and hammered home the point that it really is a question of fact whether or not a bite happens within the enclosure or outside the enclosure. Okay, so, that's the Lamoureux case. And then fast forward again about another, I think, like 12 years in 1992. The case of Booty versus Ross, 617 A2D 881. In this case, the plaintiff found himself on the defendant's land. I guess he was looking for his son. The land itself was empty, vacant, except for some old cars and like a trailer. And the land was not enclosed in any manner. There were no signs posted on the property to warn of the presence of a dog. So, in that case, the judge made the mistake of ruling in favor of the defendant. What's known as a directed verdict. Basically, saying, so in this case, the defendant said, "Oh, Your Honor, there's no proof here that this bite happened outside the enclosure, and therefore we win because the plaintiff has shown no evidence that this happened outside the enclosure, because therefore it happened within the enclosure, and therefore they have to show that this dog has bitten before." But the Supreme Court again, so the plaintiff appealed, and the Supreme Court again looked at it and reminded the lower court judges that no, the issue on this case is whether the word, the court reminded us that we have construed the statute and specifically the term enclosure to mean not only a fence or physical obstruction, but also any condition that will give reasonable notice that the land is private property. So, the fact that there is an old car, right, and a trailer box, I mean, obviously someone left that car there, right? So basically it was improper for the trial judge to kind of look at that and say, no way, no one could ever find that, an old trailer box in an old car is evidence, that someone's on private land. And that's basically the opinion of the judge, but that's not what judges are for, right? That's why we have juries. Juries decide those questions, okay? So now I want to fast forward a couple years, basically to 2014, and this is the case of Coogan v. Nelson, 92A3D 213, and this is a case where a UPS driver, what can Brown do for you, is bitten by a dog after he drops off some packages. So what happens in this case was that the plaintiff, the UPS driver, filed the lawsuit, sued the owners of the property, okay, under the theory that the bites happen outside the enclosure and that therefore the defendant homeowner is strictly liable. But in this case, the judge didn't even let the case get to a jury. So the defendant in this case argued that, well, Your Honor, clearly the UPS driver came onto our property, my client's property. It's a house. There's, he went up the driveway. Obviously, based upon the past case law, he would reasonably be put on notice that dogs could be here. There's no question where the bite happened, and it happened a few feet from the front door of the house. So, therefore, the plaintiff would need to prove that these dogs had done it before. There's zero evidence here of any of that. So, Your Honor, why should we let this case go forward? And the judge thought about it, and what the judge is supposed to do is draw all reasonable inferences in favor of the other party, the party who's not asking the court to rule in their favor, at this pre-trial motion, so to speak, okay? But the judge didn't do that. In this Coogan case, the judge looked at it and said, yeah, basically, the dogs, well, the judge made a few mistakes. The first mistake was the judge misinterpreted the one bite rule, okay? And again, the one bite rule is misleading because the statute doesn't require a bite. It says whoever kills, wounds, bites, right? So, really it's if a dog basically, or assaults, right? So I suppose assault could mean, much of anything. So if a dog just runs into somebody, knocks them over, right? Boom. That's it. That's it, buddy. You got a one knock over. So the judge looked at the case and basically said that there's no evidence that these dogs had done this before. But the plaintiff in this case objected and said, "Wait, Your Honor, no, there's some evidence that this may have happened in the year 2000, about 16 or 14 years earlier. And Your Honor, if you would give us some time, we would get those records, right? Because we think that this dog had scratched somebody before. We can get some medical records to prove that." But the judge looked at it and said, "Well, no, I mean, even if you do bring me records that the dog scratched somebody, it's not going to change my opinion because the statute requires the dog to have bitten somebody." Well, the judge was wrong there because, again, the statute does not require a bite. It requires an injury, okay? So because the judge incorrectly interpreted the requirement of the law in this case, the judge granted the defendant's motion to end the case because the judge felt as though that there was nothing left to do here. There was no reason to go to a jury because the plaintiff couldn't meet their burden. So the plaintiff appealed, and the Supreme Court ultimately not only corrected the judge and said, no, the rule is it doesn't require a bite. A scratch is fine. But on appeal, and this is very rare, the Supreme Court actually allowed the plaintiff in this case to bring new evidence, right, into the consideration of the Supreme Court that wasn't in front of the lower judge. But again, that's because the lower judge made a mistake in granting the motion in the first place. The lower judge should have allowed the plaintiff to have gotten these medical records, but again, the lower judge didn't do so because they misunderstood the requirement of the statute anyways, okay? So on appeal, the plaintiff found records that did show that the dogs had caused an injury to someone else before, and those medical records identify the injuries as bites. I mean, literally, they quote the word bites. So the Supreme Court reminded the judges and the state as a whole that, one, it doesn't have to be a bite, and two, it's not a question for a judge to decide what qualifies as an assault or a bite, okay? That's a question for the jury to decide. So the judge agreed with the plaintiff and allowed the case to continue. I don't know what happened in that case, the end. I wish I did. Most likely, I don't think I went to trial. I don't really know. It may have settled, okay? So that's kind of the history of the dog bite statute, all right? So remember, if the bite happens within the enclosure, then the plaintiff has to show that the defendant knew that this dog has done this in the past, okay? If the bite or attack happens outside the enclosure, then they don't need to prove that. They literally have to prove you own that dog and that dog bit me. And if that dog is allowed to frolic and hang around someone else's property, then that person becomes a harborer or keeper of that dog, and that person is also liable, as if the dog was theirs themselves, okay? So, if you're a landlord, you probably want to write leases not allowing dogs because, if you know that there's a dog in your lease and you allow that dog, you allow your tenants to have dogs, you have you have homeowners insurance, you may find yourself in hot water if that dog bites somebody, okay? So I would, if I was a landlord, I wouldn't allow that. So I hope you guys enjoyed the episode. I know it was a longer one. Hope you guys enjoyed, me talking about the cases. Hope it wasn't too confusing. Again, feel free to email me, lawwithdarren@gmail.com. If you have any questions, comment on YouTube or Facebook. And have a great day, guys. And episode 4, I'll try to get it out a little later this week. And I'll be going over Massachusetts, which is slightly shorter. So I'll probably do Mass and Connecticut at the same time. So either way, guys, thanks for listening. Have a great day. Take care and be safe.